and the New Life Prayer Church, Mavueni, which the respondent founded, have been linked to several occurrence book or OB reports of several deaths that occurred between 2022 and 2023 within the church precincts, where the respondent presides over as a preacher and or pastor. Counsel for the state invited the court to peruse and consider 17 OB reports of such deaths, photostat copies of which were annexed to the affidavit in support of the application, which the state urges give credence to the intelligence information of the deaths at the said church precincts. The state, it was argued, has credible intelligence and or information which revealed that some of the persons who met their demise within the New Life Prayer Church precincts in Mavueni may have been interred at Shakahola Forest, currently a secured crime scene. That upon the demise of the innocent and vulnerable followers, quote unquote, of the respondents, their bodies were preserved at a privately run morgue in Kilifi before being transported and interred on Paul Mackenzie's land in the Shakahola Forest, and could well be among the bodies that have since been retrieved from the property in an ongoing search and exhumation exercise, and hence the connection between the respondents, Paul Mackenzie, and the Shakahola massacre. It was submitted that the number of bodies being exhumed continued to increase exponentially. Learned Prosecution Counsel told the court that the police were in possession of a number of burial permits that were issued to several individuals whose names and contacts appear in the said documents and were within the reach of the respondents, as they were believed to be the respondents' followers or strong believers, and the investigators therefore held reasonable apprehension that the respondent was likely to interfere with the individuals whom the state now regarded as potential witnesses. Besides, the investigators' suspicion was that the bodies of those who died at New Life Prayer Center may not have been released to their kin for interment, but may have been buried at Shakahola under quote-unquote mysterious circumstances. The court was told that although the investigators were in possession of copies of the burial permits, the same were deliberately not annexed to the affidavit in support of the motion, as the deponent thereof had the apprehension that annexing the documents was likely to endanger those potential witnesses. The state, however, explained that the same were available and would be provided to the court if the court so required. Further apprehension on the possible interference of witnesses by the respondent was expressed by the state on the basis that there may be witnesses who are yet to be identified. The state told the court that the other connection between the respondent and Paul Mackenzie was that the investigators had established that there had been a commercial transaction between the two, whereby the former had paid the latter 500,000 shillings, being deposit for the purchase of a television station, Times TV, operated by Paul Mackenzie, the entire transaction amount being 3 million shillings. In urging the application, the state relied on the authority of Republic and Gibson Kiplangat Bet. A citation is 2022 EKLR, in which the High Court, that is Gikonyo J, stated as follows. Gikonyo J stated as follows. I am quoting the citation, the authority cited. Interference with witnesses. The prosecution alleges likelihood of interference with prosecution witnesses. On this ground, the court in R versus... must I go through this now that the authorities are in the hands of both parties? So I also cited R versus Patias Gichobi, which is referred to in the same authority. The state supposed that the standard of proof as to what amounts to a compelling reason is that of proof on a balance of probabilities, unlike the standard required in proving a criminal charge, which is that of proof beyond reasonable doubt. Now, to the respondent's submissions, the respondent opposed the state's application for the order sought of pretrial detention or detention before a charge for 30 days. In his view, Mr. Magolo, learned counsel for the respondent, stated that what the court was being asked to do at this stage was to suspend the right to liberty, which is protected under the Bill of Rights, yet no reasons or no tenable reasons had been placed before the court to warrant such curtailment of the respondent's liberty. Mr. Magolo took the view that the instant application was presented before this court as a desperate measure by the state and the prosecution to be seen to act in a situation of embarrassment after the nation dawned to the unfortunate event dubbed the Shakahola massacre, which counsel states or stated was exclusively connected to Paul Mackenzie and not the respondent in this matter. Counsel stated that the desperation arose from the fact that the state failed in terms of security and intelligence, and that his client, the respondent, is a scapegoat in the attempt by the state to be seen to be decisive following the many deaths. Counsel rhetorically posed the question, where were they when people were being killed and buried in Shakahola? While admitting that the respondent transacted with Paul Mackenzie, whereby the former paid a deposit towards the purchase of Times TV station from the latter, counsel for the respondent stated that a mere commercial activity, such as the purchase of a TV station, cannot amount to a compelling reason or a reason at all to warrant the respondent to be detained for the period that the state seeks. Counsel added that such detention can only be allowed under Article 49(1)(h) of the Constitution, where the state provides compelling reasons that would warrant the same. In further opposition to the state's application, the respondent's counsel submitted that the mere fact that the witnesses the state was referring to were said to be members of New Life Prayer Center and followers of the respondent could not possibly be construed to a likelihood of the respondent interfering with the said witnesses, who in any event remained unnamed. He referred the court to the authority of Gibson, Kipling at Bates, I've given the citation above, in which the court stated that the specific instances of or likelihood of interference with witnesses must be laid before the court with such succinct detail of evidence in support thereof as to persuade the court to deny a person bond on that grounds. Counsel for the respondent submitted that New Life Prayer Center had followers or members in the thousands, and that it was therefore not possible that the respondent would have control or influence over them, let alone know them all. In this case, counsel stated, the state did not show which particular witness or witnesses the respondent would influence or interfere with, and as such, the state had not demonstrated that there would be such influence or interference perpetuated by the respondent. In his further submissions, Mr. Magolo told the court that deaths may have occurred at the church premises, but attributed the same to natural causes, adding that it was not unusual for very ill people to be taken to a church for prayers, reminiscent of the biblical woman who had been suffering from hemorrhages for 12 years and had spent all she had on physicians who were unable to treat her, so then went to Jesus, touched the fringe of his clothes, and was healed. Counsel stated that in the event of the death of such ailing people who seek healing intervention in church, it would be outrageous to blame the administration or management of the particular church for the deaths. In support of the respondent's position, reliance was placed in the High Court authority of Betty Jamutai Kimeiwa and Republic 2018 EKLR, Judge Muridi, and counsel stated that the state is in such proceedings required to properly indicate to the respondent the likely charges that he will face, the basis for the investigations in the form of a draft charge sheet annexed to the affidavit in support of the motion. From the authority of Betty Jemutai Kimeiwa, the court was invited to consider the view of the High Court, the view the High Court had when it expressed itself as follows, while citing the High Court decision of Michael Rotich versus Republic 2016 Ezekiel'S Kimaru J. As it then was. I will not again read what the court said because parties exchanged the authorities. In conclusion, learned counsel for the respondent stated that there had not been demonstrated by the state that the respondent is likely to interfere with witnesses, abscond, or otherwise bring his trial to disrepute, noting that none of the OB reports referred to the respondent. In addition, counsel stated that while the respondent is not opposed to investigations being conducted, he should not be detained in police custody as he was ready to cooperate with the investigators and abide by and comply with any orders that this court may issue. The state's rejoinder. In rejoinder to the submissions by the respondent, Mr. Kiprop urged that sufficient grounds had been presented to the court through the supporting affidavit and a case for the detention of the respondent made. Mr. Jami submitted that the decision of Betty Jemutai was or is per incurium insofar as it referred to and addressed the issue of a holding charge sheet as the same did not consider or take the cue from the earlier authority of Samuel Cheriot Arap Langat and Republic, Chesoni J. Yazid and was, 1982 Ezekiel'S, where the finding had been made that a holding charge sheet does not exist in law. So now the issues for determination. From the record, it is instructive that the state seeks orders to detain the respondent at Makupa Police Station in Mombasa County for a period of 30 days so as to enable the investigation team to complete investigations and submit the police file to the DPP for review. The grounds that have been proffered by the state as constituting compelling reasons to detain the respondent are discernible as follows: that the investigating team is undertaking investigations relating to serious crimes that the respondent is jointly and by conspiracy suspected to have committed, including but not limited to all those offenses that are mentioned. Which by nature and gravity are serious and complex and constitute compelling grounds to deny bail. In their view. B, the respondent may influence or interfere with witnesses, and that constitutes a compelling reason for his detention pending investigation. C, that the fact that the Shakahola massacre, quote unquote, has received public notoriety renders the investigations into the same to be of great public interest, hence sufficiently compelling to warrant the detention of the respondent. Now the issue for determination is whether the three grounds above that have been presented by the state constitute compelling grounds or reasons, and subject thereto, whether there has been provided sufficient material to establish their existence. Our analysis and findings. Bail is a constitutional right as enshrined in Article 49(1)(h) of the Constitution of Kenya. A person who has been arrested on suspicion of committing a criminal offense can only be denied bail if there are compelling reasons for such denial. Thus then, the constitutional standard for denying bail to an arrested person who has been presented before court is the compelling reasons test. As properly submitted by Mr. Magolo, the burden to demonstrate that the reasons for denial of bail, that there are reasons for denial of bail, lies on the prosecution to establish the existence of those compelling reasons. That was the finding in R versus Richard Itweka Wahiti, 2016 EKLR. I'm also in agreement with Mr. Kiprop and Mr. Jami that the standard of proof required to prove that the reasons for denial of bonds meet the compelling reasons test is on a balance of probabilities. That again is as per the holdings in Republic versus Mwema Mutia, 2017 EKLR, Republic versus Mbiti Munguti, 2020 EKLR, and Republic versus Benson Mushiri Guchue, 2019 EKLR. There is no requirement under the law that the prosecution proves the compelling reasons beyond reasonable doubt. Indeed, such a standard would be impossible to meet at this point. Reference is made to the bail and bond policy guidelines at page 19. On the above basis, it is clear that the order sought for detention of the respondent is a discretionary one. A discretionary order may be issued in a case where the court has considered the material being placed before it, provided that the discretion is exercised judiciously. Again, see R versus Milton, Kabulit, and 60 others, 2012 EKLR. Then, in the case of Republic and Danford Kabage Mwangi, Justice Mativo set out what would amount basically to what compelling reasons would be. It's a long citation, but it's a long quote. But the case is Republic versus Danford Kabage Mwangi, 2016 EKLR. So I will not read through it. But of importance is he has pointed out the nature of the charges, the likelihood of the accused interfering with witnesses or suppressing any evidence that may incriminate him, and the interests of the public. He has specifically stated, he has stated many, but those are the ones that I wish to highlight. The jurisprudence that emerges from the authorities above is in part that the seriousness in nature of the offenses that are under investigation, the likelihood that the accused person may interfere with witnesses. I'll repeat that. The jurisprudence that emerges from the authorities above is in part that the seriousness in nature of the offenses that are under investigation, the likelihood that the accused person may interfere with witnesses or may suppress any evidence that may incriminate him, and the interest of the public, if the same outweighs the right to liberty of the respondent, if proved on a balance of probabilities, are compelling reasons for denial of bond. I will now turn to the issue whether on a balance of probabilities, the state has proved the three compelling reasons above. The state made allegations against the respondent that he is suspected to have committed criminal offenses or otherwise connected to Paul Mackenzie and or the Shakahola massacre, which the respondent, through his counsel, vehemently denied. It is to be remembered that this court is not at this stage conducting a trial to determine whether the respondent committed the alleged offenses or whether he has connections with Paul Mackenzie and the Shakahola massacre or not. That will be for the trial court should the position of the investigations get to that point. No doubt, the mass media, including newspapers, radio, television, and the internet, have recently been and continue to be awash with news on the still unfolding, most unfortunate events of the massacre at Shakahola Forest, and the public is generally alarmed at the discovery of bodies reported to have been buried in mass graves, pointing to possible complex criminal acts which are said to have resulted in at least 100 people being killed or starved to death over a substantial period of time. The collective interest of the public, no doubt, is that those involved in the criminal activities leading to the loss of lives of that magnitude in the unprecedented Shakahola massacre must be brought to book. The public remains anxious. Further, it goes without saying that as a preacher, and admittedly the strength behind the New Life Prayer Center, the respondent wields immense influence over his followers and congregants. This perhaps is best portrayed by the mammoth attendances that he attracts in the church services, events that he holds, as has been seen in the past from media reports. It is pursuant to that I am persuaded by the state that although the affidavit in support of the application talked of interference of witnesses who are not named, but only referred to as the respondent's followers or church members, the respondent indeed has influence over persons whom he may not himself know, as the names have been withheld, but who may be witnesses, more so considering the fact that the state has expressed fears that such witnesses may be interfered with in the event that their details are disclosed. The matter concerning the Shakahola massacre, as stated above, is one of great public interest. The state urged that the respondents may be linked to the same, and having found that it has been proved on a balance of probabilities that there is a possibility that the respondent may interfere with witnesses, a good case, in my view, has been made for the respondent to be detained on the three compelling reasons of the possibility of interference with witnesses, that is one, the interest of the public is the second, and the seriousness in nature of the offenses under investigations. We have seen from case law above that any of the three grounds, when proved to the required standard, meet the compelling reasons tests. But then, the specifics of the investigations the state wishes to complete, as per the submissions of the state, are not disclosed, save for the intention to record the statements of witnesses. That being the case, this court will in the premises take it that the time sought is for purposes of recording witness statements. In my view, then, 30 days as sought for that exercise would be manifestly excessive. I opine that it would be sufficient for the investigators to carry out the exercise in a much shorter period of time, considering that the same goes to the very root of a constitutional right, the right to liberty. Now, as regards the submission by the respondent's counsel that failure by the deponent to the affidavit in support of the application to annex a holding or draft charge sheet renders the application insufficient and defective, I note that whereas that was the holding of the Kimaru J, as it then was, that indeed that such an application should fail, I appreciate the decision of Chesoni J, as it then was, in the authority of Samuel Cheruiyot Alaprangat, that such a document does not exist in law. It is further instructive that from all other decisions cited above, that the court did not refer to the document known as a draft or holding charge. Of course, a challenge is posed to this court when two conflicting authorities are presented before it, but it would obviously not be in the place of this court to declare or make a finding that the decision of Betty Jemutai Kimeyua is per incuriam, as suggested by Mr. Jami, for not considering. I know you want me to repeat that. Mr. Jami. Of course, a challenge is posed to this court when two conflicting authorities are presented before it, but it would obviously not be in the place of this court to declare or make a finding that the decision of Betty Jemutai is per incuriam, as suggested by Mr. Jami, for not considering the position that Chesoni J took on the matter in the decision of Samuel Cheruiyot Araplangat. Doing so would be stepping outside the limits of my jurisdiction, more so considering that the two decisions were by courts superior to this court and courts of concurrent jurisdiction, the two courts. In my view, it is adequate that the respondent has been informed through the instant application and supporting affidavit of the reason or reasons I'll repeat that. In my view, it is adequate that the respondent has been informed through the instant application and supporting affidavit the reason or reasons for his detention in line with Article 49(1)(g) of the Constitution, having been brought before this court within 24 hours of his apprehension. In the result, being of the foregoing inclinations and being of the belief that the state or police have continued to make good use of the period of about 5 days during which the respondent has been in police custody at Makupa and Port police stations in Mombasa, I will allow the state's motion dated 28 April 2023 in the following terms. That the respondent shall be detained at Port police station Mombasa for a period of 7 days, which period shall run from the 27th of April 2023, being the date that he was arrested and placed in police custody. For avoidance of doubt, the detention period herein shall lapse on the 4th May 2023 at 0900 hours. I'll repeat that. That the respondent shall be detained at Port police station, Mombasa, for a period of 7 days, which period shall run from the 27th of April 2023, being the date that he was arrested and placed in police custody, and for avoidance of doubt, the detention period ordered herein shall lapse on the 4th of May 2023 at 0900 hours. I hope that is clear. B, that this matter shall be mentioned on the 4th of May at 9 in the morning for the state to appraise the court on the status of the investigations and for further orders. C, parties to be at liberty to apply for any other appropriate, relevant and/or desired orders. And orders accordingly.
Thank you very much. We appreciate. We don't receive such resource meetings on them. Your Honor, I was seeking a small clarification with the last part.
You'll get a copy of the ruling, eh? I'll print it right away. You'll get copies.